sharp as obsidian, cutting through the lies. Heavy boots stomping on corruption in disguise. No more cash for kids, we're blowing up the schemes. From the swamps to the courts, dismantling their dreams. We rise, fists high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Coward suits, sticky fingers in the till. Eviction notice served, we bending iron will. Paper trails, burning fire sparks the night. Shadow lurking, leeches bout to flee the fight. Polluted waters run deep, but we purify. Cleaning out the sludge, leaving no alibis. Obsidian sword swing, heads roll clean. This a reckoning, felt but never seen. We rise, fists high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light. But we the burning light. We rise, fists high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light. Light, 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 light. Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light.
Good evening. How's everybody doing tonight? I know we weren't on last week. We had some things going on, so I was unable to come on. I don't know if I'm going to have guests tonight. We'll see. Right, so we're just going to get this thing started. First off, our country has got a child protective services problem, and it's not going away. It's not going to stop. It's not ever going to be where this system solves the problem. It's just not going to happen. Okay, no matter how hard it tries, it'll never get to everyone's kid. Because eventually, the incentives, the bribery on the back end of that, yeah, eventually they'll go after everybody's kids. Because that's what they do. That's what they do. So here tonight, I know I've went over this probably before. I wanted to go over some things tonight. If I can find it. Where'd it go? Dang it. I had a bookmark, but it fell out when I came outside. There it is. There it is. So I usually give the case decision of the night and some news. I feel like if everybody goes over my channel or has been on this channel, they know quite a bit of case decisions. So I'm just going to give the usual. Reno versus Flores, the best interest of the child is not the legal standard that governs parents' exercise of custody. Between two natural parents, probably. But it's not the legal standard by which you are to govern your children. And there shouldn't be a custodial or non-custodial parent. That shouldn't be a thing, right? Hey, Athenia, how you doing? Good to see you joining the conversation here. So Reno versus Flores, the best interest of the child is not the legal standard that governs parents' exercise of custody. Troxel versus Granville held the 14th Amendment protects the fundamental right of parents to direct care, custody, and upbringing of your children. Due process clause does not permit state to infringe on the fundamental right of parents to make child rearing decisions simply because a state judge believes a better decision could be made. Washington versus Glucksberg was a case about physician-assisted suicide. Fundamental rights are a part of American tradition. Physician-assisted suicide is not a fundamental right ingrained in American tradition. Parental rights are. Okay, and he was trying to get help from the kid was trying to get help from the physician to kill himself. And they said, the kid don't have a right to that, but the parent does have a right to stop the kid from doing that. Basically. Oh yeah, lots of paperwork. Santosky versus Kramer. Parental rights do not simply evaporate because one has not been a model parent. Parental rights do not evaporate just because the state has assumed temporary custody. Parent and child share a vital interest in the prevention of the erroneous termination of parental rights. And we'll go with Parham versus JR. The parents are presumed to know what's in the best interests of their children. The statist notion that the government power should supersede parental authority simply because some parents in society abuse and neglect children simply because a parent's decision is not agreeable with the child or involves risk is repugnant to American tradition and does not transfer parental authority to the state. So that's the start. Okay, so for CPS, that means there's a strict scrutiny standard. Where is the affidavit where somebody claimed you abused your child. There has to be a written statement somewhere. Where is it? And is there any lies in that? Because I bet you there's a ton of lies in there that you can point out. And that has to be public information because a public officer signed their name on that document, which would be a notary public. Unless they don't have a document and they just have some witness statement. Okay, but then you have to have the physical witness there making the claim. Do they have that? I bet you that they don't. Okay, and the preponderance of the evidence standard is unconstitutional when it comes to your parental rights. And I got case law on that. I got a ton of case law. So much case law. It never seems to end. It's never going to end until you're done with it. But you know, they just keep stringing you along, hoping they'll wear you out. Thing is, the CPS has a state plan. Okay, and I did a video on this. I haven't memorized the code yet, but I have it. And that state plan is a plan to violate your rights. It's contained in that plan, them doing that. And because it's a state plan, that makes it color of state law, which means it's deprivation of rights under color of state law, which means 42 U.S.C. 1983. And they can't use Rooker-Feldman to block it. They don't get 11th Amendment immunity because the 11th Amendment doesn't apply when it's someone who resides. They like to say reside. Somebody who domicile within a state against the state itself. That's supposed to be heard in federal court or Supreme Court. When it's state versus state, it's supposed to be in Supreme Court. But the Supreme Court may elect to take a case. That's their form of jurisdiction. They don't have the regular form of jurisdiction where they're required to have a certain amount of cases every year, but yeah. Defamation, malicious slander, libel. Oof. Ooh. Ooh. No, 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 no. They can't do that. They can't block you from seeing your daughter's medical records. That is illegal. It's got to be illegal. I don't know what state you're in, but it's got to be. Yeah, I feel you. They like to go on the internet and label you fentanyl dealer when you're posting about the fact that the government made fentanyl. So how did MS-13 get their hands on it if the government made it? Does that make any sense? Oh, but you reveal that information, they're going to call you a fentanyl dealer. Censorship. Had a good load of that. I can't even get on any of the Facebook groups and post anything or post any comments, or I can message people. I can post things, but I can't share any links. Yeah, yeah. So the thing about that is they're not a judge, they're a contractor. Why are they a contractor? Because CPS also operates based upon a contract because they have a state plan. So he wasn't a judge, he was a contractor. But he was originally a judge, but he threw off his oath of office to take on the state plan and enforce CPS statutes upon you. And that was done under color of state law, and it was a deprivation of your rights, and they don't have immunity. They can be sued for that if they take your rights, but they didn't take away your rights. Oh, yeah, that if he was pretending to be a judge, he was a contractor. He did that under a contract. Um, another thing is judges acting in their judicial capacity can't just take away your parental rights for without just cause, without due process, without probable cause, with none of that. They can't even take the case. They can't rule like that. It's not how that works. I hope they know that. But yeah, oh yeah, you'll be on and on with them for years and years. Yep. Ridiculous, isn't it? These family courts think they own family rights, but they're about to find out something different. So in news today, Maine has failed to comply. So Maine got sanctioned by Pam Bondi about a week back. Okay. Maine legislature, everything for their family code is repealed. They are unlawfully holding a man, and I want to know where the body is. I want to know where the body of that man went. So I'm sure we'll figure that out in the process of what happens. At any rate, other news. Vinny's doing all right. He said hey to everybody. He's hanging in there. I don't know what's going on with Punisher. It seems to be a family issues. I don't know if it's him or I get confused because I wasn't here last week. So, but so what I wanted to kind of go over here today was a little bit of child support stuff because I was hoping my child support folks would come take a listen too. Thing about CPS is they're violating a bunch of laws and they're violating a bunch of Supreme Court rulings, and they operate just the same way that the child support people do. It's the same process. And what I'm about to reveal today will explain that process in a grievous detail. And I'm gonna hit the microwave, warm this coffee up a little bit. You know what I'm saying? And then I'll yeah, that's the thing about motions. They can ignore motions. You got to file your own lawsuit and a demand with a separate court in the federal district where your rights are going to be upheld, not in the same courthouse as the one you go to where you think it might be a courthouse, but it's actually an administrative hearing because it's all done under color of law. But I'll get into that. Color of law is the resemblance of legal authority. Title 42 was never signed into positive law. Although it may have several enacted statutes, it's not positive law title, which means it's all done under color of law, which means 42 United States Code 1983 lawsuit applies, and 242. But the 242 has to be done by criminal complaint to the Attorney General, and they're not going to help you on child support or on these contracts because on these particular things, they have something called the debt collection account, debt collection improvement account, where the Attorney General is helping them out. So that's why you have to come at them with the 1983, because the 242 ain't going to work as long as they're accepting bribes. Maybe if Pam Bondi stopped unknowingly accepting bribes, because I don't think she knows it's happening. It's happening in the background of her department. But yeah, Pam Bondi right now is accepting bribes. It's pretty fucking disgusting, but it's not her fault. I don't mean to curse. I'm such a sailor. I gotta stop doing that. All right, this is family friendly. Family friendly. I have to be here. Okay. So let me explain how this happens to everyone. 5 United States Code, Section 551, that'd be subsection 8. License includes the whole or a part of an agency permit, certificate, approval, registration, charter, or membership. What's a bar card? That's a membership. What's a bar card? That's a membership. What do you have a right to make an honest living? Okay. Statutory exemption or other form of permission. So a license includes a certificate. Okay, so I checked, and the birth certificate is issued by an agency. Okay, so a certificate is included in the definition of a license. Keep that in mind. Birth certificates are issued for a fee. You pay a fee and they go issue you a birth certificate, right? In the United States of America, the state issues the birth certificate, not the federal government. A certificate is included in the definition of a license. The Supreme Court has many times affirmed parental rights. Parental rights are considered a fundamental liberty and aspect of individual liberty. They are considered a liberty, protected by the due process clauses. When you certify or register your human offspring, they become children and property of the state, which the birth certificate signifies, as it is included in the definition of a license, which means a statutory exemption or other form of permission. Do you need permission to observe your right to your human offspring? If it is a fundamental liberty, I don't think so. Okay? The birth certificate signifies as a license that can be revoked as a privilege. If the social service agencies don't like your parenting methods, the birth certificate certifies that the state has given you permission to parent. But if they don't like what you're doing, they can come try to intervene. We got a little problem with that today. That is why the government asks you if you want a social security number, okay, for the child, which causes them to become federal property. If they agree to represent the number by presenting the number, this is done through the U.S. citizen checkbox on the Social Security card and number application SS5 form. The Social Security number is not a form of identification for human beings at 20 Code of Federal Regulations, Section 422.107, and is the registered property of the Social Security Administration at 20 CFR 422.103D, and must be returned upon request. It does not identify your child or the 42 United States Codes 666A3C non-custodial parent, assumed to be myself and others, under violation of Santosky versus Kramer and Troxel versus Granville. That is actually the Social Security Administration itself, due to it being their property. Thus, the obligor / non-custodial parent is divested of its 13th Amendment right to be free from involuntary servitude, and thus the Social Security Administration, by abuse of legal process on behalf of the Office of Child Support Enforcement and all child support agencies, owe the Social Security Administration the amount they say that I, the living man, under Article 1 in the preamble, being born free, equal, and independent, living on the land, as well as everyone else affected as personages of the Social Security Administration and or all other living men and women affected. Thus, the child support enforcement agencies must pay out to victims in SSA by law, as well as the violation of mine and others' religious liberty that was violated in the attempt to render me the 42 USC 666A3C property identified as the non-custodial parent / obligor that is the property of the Social Security Administration at 20 CFR 422.103D, which is impossible under 20 CFR 422.107 for to be me or any other living human being, and Even if it were under 42 United States Code 1994, it makes failure to pay child support obligation void and thus not a crime. Thus, the 13th Amendment claim is sustained because of that fact. The state has now tried to demand payment of a debt in Federal Reserve notes as legal tender and due to child support or other contracts, such as the CPS contract, being a violation of your rights, or in this case, child support, a debt. The state is in violation of the legal tender clause, or in the case of CPS, in violation of the 10th Amendment prohibition on states interfering in family matters under the Supreme Court case, Griswold versus Connecticut, that establishes there's a private realm of family life of which the state can virtually not enter whatsoever. Santosky versus Kramer also says if they take your rights away, they really didn't. It is really a violation of your rights, and they just temporarily took them away. You can go demand them back. We're 42 United States Code 1983 lawsuit for deprivation of rights under color of state law. And I'll get the code. I'll get the code to you probably next week. Okay? That's for you CPS folks. Here's for you child support people. Being a debt collection, the state is in violation of the legal tender clause because they are asking, okay, for payment of a debt in something else other than gold or silver, which is prohibited. States are prohibited from doing that due to the legal tender clause. And there is no more gold or silver in circulation due to it running out due to the Emergency Banking Act of 1933. Okay, so we're going to continue on to 42 United States Code 666 also violates the right of trial by jury under the 6th and 7th Amendments on its face. Okay? So within 42 USC 666, it has a statutory presumption that they can deny you your right of trial by jury in a paternity establishment procedure or proceeding, which they cannot do, because that is civil. Okay, but later on they make it into criminal because they have a quasi-civil, quasi-criminal jurisdiction, which means they do not have jurisdiction. Have a nice day. Here's another one. Okay, so as well as freedom of religion, the child support enforcers are 42 USC 659B private persons. Same with CPS. They're a private person if they're acting under a contract. CPS is done under a contract. I can find you the state plan. The state plan is the contract. When it's done under the state plan, that's premeditated. If you find deprivation of rights in that code, which you do, it's premeditated deprivation of rights. What is it? A state plan, premeditated deprivation of rights under color of state law. And your damages go off based off of your state damages claims. Ask for equitable tolling because you didn't know any of this, or if you did know any of this, you need time to prepare, right? So it's up to you to show the court why you need extra time. But I'm sure we all got our reasons, and I'm sure they are all valid, including but not limited to lack of education, lack of knowledge, lack of perception, lack of time, all sorts of reasons, man. Because the way they slam you, you start learning about it, and they hit you and lock you up, and then now you're in jail and you can't fight it while you were learning. But see, that's a deprivation of your right to your Second Amendment right to defend yourself in a court of law using legal procedure. Okay, and through the due process clause. If you don't believe me, that is under your right to defend yourself under the right to bear arms. It's included in that. Because of the presumption of that is the right to bear arms is to roll up your sleeves. If somebody wants to hit you and fisticuff with you, they can catch one back, bro. And the police ain't supposed to be putting you in jail for that when you get in a fisticuff that you agreed to. That's consensual. You know what that's called? That's called UFC. Oh, what do? They license it. What is it? I bet you it's a state. I bet you it's a state agency. I bet you. Okay, so we're going to continue here. Okay. So you're going to learn a lot from this, even if you're not in child support. You can adapt it through the use of different numbers of rights. You have so many rights that you don't even know how to invoke them. There's just so many of them. Okay. And we're going to get into it. Is this going to be good for everybody? Okay. So how's everybody going in chat? How you going, chat? Love you guys. Keep fighting that parental rights fight out there tonight and today, wherever you may be. Okay. They are private persons with no immunity from lawsuit or legal process, acting under color of law under the 42 USC 654 state plan for child support, which makes the threatened or actual abuse of legal process, which happens as a form of forced labor and involuntary servitude under the 13th Amendment, violation valid because of 31 USC 3720D wage garnishment that violates the 13th Amendment, 42 USC 1994, and the separation of powers doctrine, as well as Murdoch versus Pennsylvania, that states that no state shall convert a liberty, such as the liberty to direct the care and custody of your offspring as you see fit, not as some capricious bar association or the state government or some child protective service agency or some child support agency sees fit, but as you see fit, and they can't convert that into a privilege and license it for a fee. And furthermore, if the state or someone purporting to be the state converts a right or a liberty into a privilege, the citizen can ignore the license and fee and engage in the right with impunity, which means immunity, which means they can't punish you, which means citizens may not be held as property also due to the 13th Amendment and 14th Amendment. Marbury versus Madison and Norton versus Shelby County renders birth certificates, licenses, social security numbers void ab initio. A motion for summary judgment based on conclusions of fact, finding of truth and law, and conclusions of law and evidence, requesting damages both real and personal. And these are some of your rights, man. Your freedom of these can be litigated under 1983. Your freedom of speech, your right to travel between states, your freedom of movement within a state, which includes automobiles, right of securing and defending property, which includes your Second Amendment, which includes all these licenses in order for you to have a firearm. You don't need none of that shit. It's all unconstitutional. In fact, Donald Trump has done an executive order. Okay. The only time the Supreme Court ever ruled on a Second Amendment was to say that sawed-off shotguns are illegal because people were using them to conceal a shotgun as a higher caliber weapon to do more damage to police officers in the line of duty, which is disgusting. But at the same time, you don't get to infringe on people's rights, bro. Okay, so you got the right of securing and defending your property and your liberty. You got the equal protection of the law. You got the right under it's Bad Elk versus United States to resist unlawful arrest, bro. Okay, and then that's up to the point if they try to commit murder against you, you can murder them, and you can get away with that murder because that would be done in self-defense. Okay, if you have proof. So always be recording shit. Always. I don't care what you're doing, man. And whatever you do, don't willingly commit a crime. Willfulness is one of the biggest cause of people committing a crime ever. But here's the thing. They cannot stop. Go lay down. Go lay down. Dang, man. Go lay down. Stop. Go lay down. Go lay down, dude. Hold on, y'all. Hold on a minute. I think this finish up what I'm doing. Holy moly, thank you. Yeah, you can. I'll be out in a minute. Sure, you got a delivery. Back to her. Where was I? You got the right of securing and defending your right to life, liberty, and property. You got the equal protection of the law. The law must be it must be equal. It must protect equally. It must be enforced equally. Okay, so you can't go charging somebody for being black, charging somebody for being a female, charging somebody for these are all things that are protected. Okay, so stop, Kansas. Stop, man. You got the right to vote, the right to trial by jury in civil and criminal proceedings. You got the fundamental right of being born free, equal, and independent, like I had just previously stated. You got the freedom of journalism, the right to fair legal proceedings, the right to access the court, the inalienable and unalienable and unalienable and inalienable parental rights of care, custody, and raising your offspring, the right to petition government for redress, the right to report a crime, the liberty, interest, in procreation. Okay, your human offspring cannot be carted off to another state to be castrated under gender affirming care. That's void. Okay. You got the right to life, liberty, and pursuit of happiness, privilege against self-incrimination, freedom against re-prosecution, right to remain silent during investigation. You got the right to privacy, okay, to your private information and to your private domicile, such as your bathroom, areas that are known to be private, like private property that has a sign posted. Okay, when you're on public property, you can record anything you see. I don't care what anybody tells you. You can record anything you see when you're on public property. That's why you have blinds on windows so people can't record you or look in your windows. And this is to protect your right to privacy. That's why blinds were made for windows. Okay. So we're gonna right to remain silent. So that goes with okay, your information. You don't they make it seem like there's a law that obligates you to give them identification if they ask for it. If they cannot articulate a crime, no, there is not. No, there is not. And so you got the right to withhold your private information from government intrusion. Also, under Duchesne versus Sugarman, you got the right to resist unlawful or excise intrusion into the family by the government. Okay, that's Griswold versus Connecticut establishes a private realm of which the state cannot enter. Okay, Santosky versus Kramer protects your parental rights even if they say you lose them. Okay, and so now my dog has interrupted me and I can't even think. Stop doing that. Go lay down. Naughty. Let's see. Freedom from debt bondage, peonage, involuntary servitude, and slavery. You got the freedom of religion. You got the right to familial association. You got the right to not or to expressively associate with anyone or any legal corporation or any living person. You got the right to not associate with any of them or associate with any of them if you so choose. Which is why you keep going down there to the state courts, which is why you keep getting your rights taken away from you, because you won't go file your own lawsuit to protect and defend your own rights that you already have. Okay? That's what the statute's for. It wouldn't be there. It wouldn't be there otherwise. Okay? You got the right to bear arms, the right to form a militia, Okay, they tried to take that away from us with a Senate bill recently, and give that power to Mr. Joe Biden. Okay, right. You got the right to own weapons for defense. Well, when he was president, anyways. You got the right to own weapons for defense. You got the freedom of self-defense with to defend yourself if somebody assaults you, man. And the police, they can get trespass charges, they can get assault charges, they can commit crime just like anyone else. They don't get immunity from criminal activity, and they don't get immunity from violating your rights. The doctrine of qualified immunity is dead, bro. It's dead. Okay, and I got the case law to tell you it's dead. I'm working on a list that it's going to knock everything out of the water, man. These case indexes that I have are really great. I'm working on some more. But anyways, you got the right to familial and religious privacy. You got the right to medical confidentiality. You got the right to or not to contract and to terminate or to right. You got the right to make a contract, enforce a contract, or terminate a contract. Anybody who's involved. Okay, you got the right to choose employment. So obviously, when the child support people order you with a seek work order to seek better employment, that's taking away your right to choose employment, isn't it? Okay, and they do that under a state plan, which makes it color of state law, which means it's deprivation of rights under color of state law 42 U.S.C. 1983. That's a lawsuit. These are your rights here, folks. Freedom from quartering of troops in private domicile, freedom against unlawful trespass on one's property or domicile, freedom to gather peacefully, the right to protest, the freedom from false warrants, the right against unlawful searches and seizures, the immunity to unconstitutional statutes, immunity to foreign prosecutions, the right to truth and evidence, the intangible right to honorable services from the government, which they're violating, the right of consensuality, meaning it must be consensual, freedom from being physically assaulted, the right against theft, the freedom of press, the freedom of person, your personality, not your legal person, but also your legal person. Both are secured under the Fourth Amendment. So that means your identity, and that means you as a physical body. Okay. You got the right to grand jury on capital offense, the privilege against double jeopardy. You got the articles of impeachment clause to file impeachment, to impeach officers with your senators and representatives. Okay. You got the right to due process of law 3 times over. Declaration of Independence, 5th, 14th. Sorry, gotta clip the nails. It's been a minute. You got the right to just compensation upon confiscation. You got the right to a speedy trial for defendants. You got the right to a public trial, which means you can record. Which means if you ask for a trial and they give you a trial and they tell you can't record it, blah 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 blah. They tell you some stuff about the First Amendment you can't record in here. Bullcrap. If they give you some bail condition that is like you can't work or you must work or no, you don't. Okay. You got the right to record court proceedings because of that, because of the right to a public trial, and for your records to make sure that there's not all of this family court corruption, false documentation. They like to use fictitious instruments, and they like to make up affidavits with AI and all sorts of stuff, man. And so you got the right to record in public. You got the right to record court proceedings. You got the right to record criminal activity for evidence. You got the right to an impartial jury. You got the right to know the nature and cause of the accusation of the charges being held against you or the defendant if you choose to represent yourself. Okay? Social Security number's not you. It's not a form of identity. All right. Because obligors are identified by Social Security numbers, and Social Security numbers do not identify human beings. You got the see with that birth certificate voided out. Guess what happens? State's got to release your kid. They don't got no right to him to begin with, and they need to give you back your title, which was the certificate of live birth, which they don't have. Yeah, that would be at the DHS office, at least here in Michigan. So the DHS office here in Michigan, the people in charge of child support are the same ones issuing the birth certificate. They're also their number, the Social Security Administration's number, is what the IRS uses to identify you in their records for taxing your income. I want to think about that. Also, the 16th Amendment states that Congress shall have the power to levy and collect taxes, not the executive branch. Congress did not have the power to delegate that authority to another branch of government. That is a violation of the separation of powers doctrine. The IRS is unconstitutional, and so are our current form of income taxes, which should be replaced with tariffs done correctly. But I don't know. That's neither here nor there. It remains to be seen whether that's being done. We'll go find out, I'm sure, when we all either run off of an economic cliff or go into a economic climb. We'll see. We'll see. Oh, by the way, Maine's getting sanctioned. You get no more federal funding. You ain't getting no more federal funding because you continued to let women play in men's sports. So Pam Bondi's revoking your funding through Donald Trump because they have the power to do that because they're the executive branch and Congress delegated them the authority to regulate that. Wonder if it was unconstitutional for Congress to do that. Bet you it was. Bet you it was. But that's not the executive branch's problem now, is it? Okay, moving on. Where was I? Public trial. You got the right to record court proceedings, to record in public places, to record criminal activity, the right to an impartial jury, the right to know the nature and cause of the accusation, the right to be confronted by witnesses against you in criminal trials, the right to witnesses in favor of you as a defendant, the right to appoint or not to appoint an attorney, or not to appoint an attorney due to 7 Corpus Juris Secundum Section 2 and 3 that states that an attorney's first duty is to the court. But here's the thing. They also swear an oath of office when they finish law school. They're supposed to. They don't do it anymore. They used to. That bar card's a membership card. It's a license. Their right to work and contract their labor as they see fit has been converted into a privilege by the state by the issuance of the license of the bar card, which is a membership, which is included in the definition of a license, which means every attorney and lawyer has had their rights violated by the state. Also, the license to practice law is supposed to be issued by the Supreme Court, not the Bar Association. Also, licenses that convert the liberty, such as the liberty to choose your labor and your time on this earth as you see fit, and converts that into the privilege, okay? And we'll go into that. It's Murdoch versus Pennsylvania, okay? I believe I went over that. I believe. Oh, no, I didn't. Interesting. You sure? Oh, yeah, right here. Murdoch versus Pennsylvania, state shall convert a liberty into a privilege and license it for a freedom. Furthermore, if the state converts the right or liberty into a privilege, the citizen can ignore the license and fee and engage with the right with impunity. Okay, and that's Murdoch versus Pennsylvania. In just 1 second. The Shuttlesworth versus city of Birmingham, Alabama is the one that says that if a state converts a right or a liberty into a privilege, the citizen can ignore the license and fee and engage in the right. Okay, so there's no such thing as a license to practice law. I don't know who told you that, Mr. Bar member, but it does not exist. Okay, because Marbury versus Madison and Norton versus Shelby County. Okay, and Miranda versus Arizona, a constitutional right cannot be converted into a crime. Okay. Yeah, and you got the right to be confronted by witnesses against you. You got the right to witnesses in favor of you. You got the right to appoint or not to appoint an attorney. You got the right to a trial by jury, both civil and criminal. Civilly, if it's over $20. Okay. Criminal's a bit different. But essentially, you got the right to trial by jury. And child support, they deprive you of that. Okay. So you got the immunity to retrial of jury trials unless under the common law, which would be the Constitution, Supreme Court cases, and the statutes of the United States Code and statutes at large that are pursuant to the Constitution and not in conflict thereof. Okay? So you got the right against your rights being used to violate other rights. Okay? You got the right to retain rights not enumerated. That means not listed. You got the right to powers not delegated or prohibited. Okay? Because as a state citizen, okay? Immunity to laches. Okay, laches is a species of action in which a private right of action is denied due to late filing on a constitutional question, but that immunity to laches for lack of knowledge or information. Maybe you didn't know your rights. Maybe you didn't know a part about the law. Okay. Immunity to void instruments, right to own property, and immunity to laws that contain criminal activity as a method of enforcement, freedom from jurisdiction upon lack of due process, privilege and immunity against treasonous action, 18 U.S.C. 1381, right to find and use methods to protect rights, the right and immunity against suppression of constitution, even in times of national peril. Okay, immunity to unconstitutional abuse of authority. You've got the right to declare unconstitutional laws as unconstitutional and ignore them. You got the right to demand declaratory judgment about a law you deem unconstitutional. They must be unable to be enforced without a violation thereof of the Constitution in order for a court to declare them as such. But you can declare them as such if you can prove it, and you don't need a court. It's not for a law is not unconstitutional from when it is decided it is unconstitutional in a court. It is unconstitutional from its very beginning. How do you think statutes get challenged and overturned, as it were? You got the freedom from imposition of charges for the exercise of a right. You have the right and freedom to conversion by states of secured liberties into privileges to be licensed for fees for arbitrary deprivation thereof. You have the immunity to license and fee conversion. You have the right against conversion of rights into crimes. You have exceptions to willful intent. You have right to that would be an immunity, your exception to willful intent. What is an exception to willful intent? It's up to them to prove that the burden of proof is on he who asserts, not he who denies. Okay? The exceptions to willful intent would be if something is against the Constitution, how can you willfully intend to disobey it when the Constitution prohibits it? There you go. That would be an example of your exception to willful intent. Okay, and using willful intent. Okay, so you can go like this. Oh, well, do you have proof that I intended to break the law? Because the statute you're trying to use uses willfulness as a determining factor of its responsibility. See what I'm saying? Okay. You got the right to remove unconstitutional public servants. You got the freedom of force. You got the freedom against forced signature of legal or illegal instruments. You have the right to have a lawyer present during interviews or interrogations or investigations. You have the right to refuse to identify under your right to privacy. Your identity is also protected. It is personal identifiable information. A state officer is prohibited from abusing that information. You have the right to refuse questions because you have the privilege and immunity against self-incrimination. Okay. You have the right to have a lawyer present. Okay. You have the right to appoint a public defender or not appoint one. You have the immunity to interrogation after observing the right to remain silent expressly by expressing it vocally. Okay. You have the immunity to abolition of constitutional rights. Your rights cannot be abolished. You have the freedom and right against conflicts of interest. Okay. Subject matter jurisdiction is the ability of a court to hear and determine a case based on whether the court was intended in originality to hear it upon the court's implementation. Now, let me ask you something. Is there such thing as a child support court? No, there is not. '42 United States Code 660 Civil Action to enforce child support and spousal support obligations. Void. Jurisdiction. Void. Obligations, void, 42 U.S.C. 1994. So civil action to enforce child support and spousal support obligations, 42 United States Code 1994. The holding of service of labor of people as peons and liquidation of any debt or obligation is void. Jurisdiction. It's void jurisdiction of the district court. So why are you in a state court if you're talking about child support? You're in a state court, but it's a child support. But you're in a state court when the jurisdiction is supposed to be in the district court. According to equal protection of the law, you can request that be done, and they cannot block it under Williams versus Reed, Maine versus Thibodeau. Monell versus Department of Youth Services. Man, there's so much out there. There's Franconia Associates versus United States. You've got United States versus Lee, Butts versus Economu. They can't block your 1983 anymore. They cannot block your lawsuit. Yeah, nope. That is not a court of law. Do you know what that is? That's an executive branch court. Nope. 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 I already told you in what I already had just said. They do not exist. There is no court-ordered child support. There is no order to pay child support in this country. You want me to prove that? It's right here at... Oh, wait. It's all unconstitutional. I just read it all off to you. It's all a violation of your rights. It's all unconstitutional. Child support hearings do not exist. The reason they do not exist is because a void law does not exist. Therefore, a hearing based on a void law is a void hearing, and it cannot exist. They might hold them, but that's criminal activity. I'd prefer if you didn't come on my videos trying to argue with me about child support, because it ain't gonna work. But you can keep going down to those administrative hearings if you want. Is that what you're meaning? The administrative hearings? Is that what you're meaning? Because if you're meaning that, I mean no offense. Because then you'd be correct. It's an administrative hearing in the executive branch, not a judicial proceeding, which is in the judicial branch, unless your state uses the attorney general to enforce their child support obligations. Mine does not. We have friend of the court. Both are a violation of the separation of powers doctrine in two different directions. The separation of powers doctrine is a wheel. They cannot, as public officials, they cannot use the wheel. As a citizen, as a person who is a living, breathing man, and not a legal fiction and not a person, under that definition. Okay, that has to be said. Not a sovereign citizen, but that has to be said. So my question is this. Can you prove anything? Can anyone prove any of what I just said wrong? Because you can't. If you go look it up, you're going to find out I'm right. The right to travel is a far-reaching and essential privilege and immunity. It is guaranteed explicitly in the Constitution. Travel is defined as to go from one place or another as by car, train, plane, or ship. Driving is defined as the ability to drive a car or the activity of driving in a business for profit and commercial activity for commercial instruments. Are you operating a business out of your vehicle? Then you don't need a driver's license. a license, a right or permission granted by a competent authority to engage in some business or occupation, which is a violation of your rights. You get the right to work as you see fit, not as how they see fit. Okay, but you got the right to be properly trained at work safely. Okay, that's part of your labor, union rights, things like that. Do some act or engage in some transaction which would be unlawful without such right or permission. So let me tell you something. Is it unlawful to travel without somebody's right or permission? Is it unlawful to exercise custody over your human offspring without someone's permission? If it's a right and it's guaranteed, do you need permission to use it? No, you do not. Judicial immunity does not apply in cases involving rights violations pursuant to 42 U.S.C. 1983. Includes office and title, including representing someone in a court or giving legal advice for money without a license to practice law. That's not a criminal activity. Okay, I've got so much stuff here. Conspiracy is when two or more conspire to commit or commit a crime or prevent exercising a right. Color of law refers to the appearance of law or a law that only looks like a law, whether it is or isn't a law, and is being unlawfully enforced. Color of authority is when someone uses the power vested in them in their official capacity in such a way that overreaches its bounds and causes them to become a private person, at which they'd be considered a private person at law when the individual is not authorized or legally, because the word individual is a private person, that's an individual, that's a taxpayer, okay, so or legally able to use that power. Like illegal search and seizure. Okay. A contract is void if it breaks the law. Contracts that force or cause crimes are unenforceable. The ones that break the law are void. Okay. These are the definitions. This is based on the language of the law. This is based on the statutes pursuant to the Constitution. The Constitution, as supported by the United States Code of Law, the United States Code of Law, as supported by the Constitution, and the Black's Law Dictionary, which does have weight because that's judges' interpretations. Okay, that's not necessarily a law, but it has the force of law, just like the Code of Federal Regulations, but that only applies to federal agencies and their actors or cohorts or employees. Okay, a contract can become void if the law changes or and it occurs after agreement, but before fulfillment, if a crime is created, if somebody's rights are violated, non-disclosure. Let's see here. What else did I have? Contract is an agreement between parties. Who are those parties? That would be CPS and the state. That'd be the state and federal government for a contractual agreement for resources, and that'd be under incentive payments to states or payments to states. A contract is an agreement between parties creating mutual obligations. And you're going to tell me child support's not a contract. United States versus Sage. Yes, yes, it is. Yes, it is. And it's void. Okay, it's unenforceable. Okay, the government is supposed to help baby mama without coming after dad. It's supposed to help dad understand what it means to be dad because dad wasn't there because dad decided to leave, or more likely was the case, got put away for child support. It's a generational cycle and it needs to end. It needs to stop. People need to stop supporting it. People need to stop going down and participating in their hearings. If you're talking about child support hearings being a part of the administrative function, whether that be exercised judicially through the front of the court or through some executive branch agency, if you're saying that they do exist and they do have days of the month that they go down there, you are correct. Okay? But if you're saying it's a court, then you are not. That's the difference there. It's not a court. Not in the traditional sense. They're there for one thing and one thing only, to get your financial information. And the thing about mothers is when they go down and apply for these child support services, they're unknowingly waiving their right to collect the child support over to the state. They can no longer sue for it. They can no longer attempt to enforce it. They have no claim to it. Blessing versus Freestone. Okay. I know that hurts, because you count on that to sustain yourself if you're a custodial parent, right? Thing is, that's a violation of both of your rights, because now one parent is being placed over top of the other one. It's a violation of your child's rights, inalienable rights to get rid of the state agency being involved in your private family life. Griswold versus Connecticut. Yeah. But contracts require the basic elements for a legally binding agreement. That's very much true. That's very much true. Yes, they do. It used to be a primary caregiver presumption where only mothers were doing it, but they allowed fathers to come in and get it as well. Either way, you're missing the point. It's peonage. It's slavery. It's abolished. You're missing the point. Okay, it costs far more to care for a child. You think. You might not know how to live poorly. That might be the issue. Or you might be less frugal. Or sometimes your kid just might be a hog and need that extra resource. I mean, it happens. In the initial stages, expensive as hell. Another one is high school. Then they get expensive. Middle school is not too bad. But then again, I don't know, because that's just based off from what I know of my childhood. But it does cost a lot to raise a child. Fathers do also file for child support, and they shouldn't, because what they're doing is supporting the removal of a parent from the family unit, which is destabilizing. It causes that child to not know that part of the gender spectrum, and then you get things like gender affirming care. Every child should know that it's okay to be gay. No thanks. Keep that out of our public schools, please. And I told you, child support is illegal to enforce. That's illegal. Can't do that to someone. It's a violation of rights. Ask Nancy Schaefer. She exposed CPS. She exposed child support too. It's the same beast. And until you admit that, you will be wrong, and you will continue to have to deal with whatever you're dealing with, and whatever side of the court process you're dealing with in family. It deals with Title 42. Homeschooling. I support homeschooling and extracurricular activities for the I support parents teaching their kids about their the whole thing, the basic education. I'm all for that. All for it. Absolutely love it. Oh yes, yes. I mean, I can't wait to see my son. It's coming soon. I can see him at any time. I just gotta get this house cleaned up a little bit. I don't want him coming over with a mess being right now. But as far as the other stuff, the agency's still coming after me. Baby mama's still being trying to strip me of my rights illegally. Okay, and you tell me this. Somebody comes down to a parking lot, okay? Let's say you got separated from your kids somehow, and somebody comes down to a parking lot and says, if you don't sign this, you'll never see your son again, and you'll go to prison. If you do sign it, and you don't do exactly what we say, you'll never see your son again, and you'll go to prison. Would you call that kidnapping? as a custodial parent. So what's the difference between it happening to a non-custodial parent from it happening to a custodial parent? The difference is the non-custodial parent gets submitted to involuntary servitude. It has its first, fourth, fifth, sixth, seventh, eighth, ninth, 10th. It'd be 13th, 14th, and 16th. Here's another thing. The non-custodial parent / obligor / person who's got to pay child support is not me and is not men. It's not fathers. It's not mothers. It's not women. None of what you're thinking is what it is. Because of what I just already told you on the program here. Guess I'll go through it again. 5 United States Code 551, Section 8. License includes certificate, registration, membership. Birth certificates are a certificate. They are issued by a state for a fee. The state issues the birth certificate. A certificate is included in the definition of a license. The Supreme Court has many times affirmed parental rights. Parental rights are considered a fundamental liberty aspect of individual liberty protected by the due process clauses. When you certify or register your human offspring, they become children and property of the state, which the birth certificate signifies as a license that can be revoked as a privilege if the Social Service Agency doesn't like your parenting methods. The birth certificate certifies that the state has given you permission to parent. That is why the government asks you if you want a Social Security number for the child, which also causes them to become federal property. If you agree, and if they agree to represent the number by presenting the number, this turns them into a U.S. citizen, because this is done through the U.S. citizen checkbox that is located on the Social Security card and number application, Social Security 5 form. The Social Security number is not a form of identification for human beings at 20 Code of Federal Regulations 422.107 and is the registered property of the Social Security Administration at 20 CFR 422.103D and must be returned upon request. It does identify the 42 United States Code 66683C non-custodial parent, assumed to be myself and other men and women, under violation of Santosky versus Kramer and Troxel versus Granville, that is actually the Social Security Administration due to it being identified as their property. Thus, the obligor or non-custodial parent or person who owes child support, which is the Social Security Administration, not me, not men, not women, not mothers, not fathers, is divested of its 13th Amendment right. And the real living mothers and fathers get divested of their 13th Amendment right to be free from involuntary servitude and abusive legal process that all child support agencies commit, that also owe the Social Security Administration the amount they say that I and the other living human beings and the Social Security Administration under Article 1 owe when we don't, or when I'm the living man under Article 1 and preamble, born free, equal, and independent, and living on the land, as well as everyone else affected, as the personages of the Social Security Administration and living men and women. Child support enforcement agencies must pay out to victims and the SSA by law, as well as the violation of all of our religious liberty that was violated in the attempt to render us into the 42 United States Code 66683C non-custodial parent, identified by the 20 CFR 422.103D registered property of the Social Security Administration, which is impossible under 20 CFR 422.107. 42 United States Code 1994 makes failure to pay child support obligations void and thus not a crime. Thus, the 13th Amendment claim is sustained because of that fact. The state has now tried to demand payment of a debt in Federal Reserve notes as legal tender and due to child support. It's quotation because it's not child support. That's false advertisement on behalf of a government agents, because Blessing versus Freestone and We Hunt versus Ledbetter will show you that child support was never intended to benefit women and children. It was intended to benefit the state coffer and the federal coffer, which is the money that the taxpayer. And who's the taxpayer? The taxpayer is who they presume the obligor is, which is not you, which is identified by the Social Security number, a debt. Okay, being a debt, it being a debt, the state is in violation of the legal tender clause because they cannot accept anything but gold and silver as legal tender in payment of a debt. And they're asking for Federal Reserve notes when they ask for child support obligations. Because an obligation is a security of the United States, the Secretary of the Treasury is obligated to pay all charges and interest on the public debt. We were never legally by law obligated to pay. 42 United States Code 666 also violates the freedom of religion because it's the mark of the beast, and it's perpetrated by a 42 USC 616 actor, which is also in prophetic terms, in biblical terms, in religious terms, the Christian, there's two different marks of the beast. It's either 666 or 616. It's hotly disputed. And both titles, 42 USC 666 is a violation of your religious liberty, and it's perpetrated by a 616 actor possessed by the devil. Okay? So it's also a violation of that right. It also violates the right to trial by jury under the 6th and 7th Amendments on its face, in its wording. It says you're denied a right to trial by jury, as well as the freedom of religion, as well as your right to due process under the 5th Amendment. In their statute, it says it allows them to do that. That's illegal. You don't get to do that. An unconstitutional law is void. Marbury versus Madison, Norton versus Shelby County. You don't have to listen to it. Okay? From the beginning. Void ab initio. 42 United States Code 659B, private persons with no immunity from lawsuit or legal process that are acting under color of state law under 42 United States Code 654 state plan, which makes the threatened or actual abuse of legal process and 13th Amendment violation valid. Also 31 USC 3720D wage garnishment violates the 13th Amendment, 42 United States Code 1994 and the separation of powers doctrine, as well as Murdoch versus Pennsylvania, which states that no state shall convert a secured liberty into a privilege and license it for a fee. And furthermore, if the state converts a right or a liberty into a privilege, the citizen can ignore the license and fee and engage in the right with impunity. Citizens may not be held as property due to the 13th Amendment and 14th Amendment, plus Marbury versus Madison, Norton versus Shelby County renders birth certificates, licenses, social security numbers, fishing licenses, gun licenses void ab initio. I motion for summary judgment based on conclusions of evidence, fact, and law, and finding of truth and conclusion of law, requesting damages both real and personal. Y'all have a good night, okay? I'm out of here. I gotta go.